Okay, please be seated, state.
Thank you. Good afternoon, ladies and gentlemen. The state has afforded the opportunity to address you again briefly to talk about some of the things that defense brought up. So I'm going to start with the reasonable abuse of justified force. The main part of that, what defense didn't bring up, was the fact that you have is to meet force with force. So it's not just you can automatically do it. Meet force with force. And the standard that you use to look at that is you must judge the defendant by the circumstances by which he was surrounded at the time the force was used. And this is a reasonably cautious or prudent person. So let's talk a little bit about some of the items that defense brought up. The burglary part with that, it almost sounds like if he came into the car at all, then it's self-defense. No, ladies and gentlemen, it's very clear from Wendy's testimony, and you have to rely on your recollection of what the testimony was. You cannot go and say, well, defense said, oh, she said to this Arbelias, you never heard from anyone by that name. So that was never in front of you. So you can't rely on that. Just what the attorneys say is not evidence. You have to rely on your own recollection of the evidence. The burglary is only if that was to commit a crime. The state's position, and Wendy's testimony was very clear, that Muhammad is in a bear hug with the defendant, and that's how they wind up in the car. Not that he dives in or anything else. So let's talk about the fingerprints that are or not on the outside of the car. That's why it's important to call the cops. That's why that's important. Because that statement, where the victim allegedly opened the door, isn't given until June. June! This happened in April. The car's processed in May. If the cops had been called right away and they had that story and that was what had actually happened, then that could have been looked for. You don't know what you don't know. And the defense in this case is trying to say, well, they should have done that just because. There was no reason to do that. There was no testimony, there was no evidence, nothing that clued the cops in to look for fingerprints under that door. Nothing. To try and say that, oh, you need to know A, B, and C. No, ladies and gentlemen, we agreed that the state only has to prove it beyond a reasonable doubt. It's possible I'm going to win the lottery, but it's not reasonable to go and quit your job based on that. We talked about that in jury selection. So, Wendy's testimony was not that Mr. Knight, the victim in this case, got out of his car and talked to random people. She said he got out and talked to people he knew. Think about this, ladies and gentlemen. Corey's neighborhood, his parents live there, he has lifelong friends there. If he thinks he knows someone in the car ahead of him, then that's perfectly in line with his character for him to do that. Discussion about if the defendant was inside or outside the car. Here's the kicker on that one. Wendy was able to identify a photo of Armando Baptista. If he never got out of that car, how does Wendy ID him? How does she say how tall he is? Ah, there's a good one, right? Because how would she know in her statement how tall he was unless he was standing up next to the victim? Little things. The devil is in the details, ladies and gentlemen. The details are what matter. On that, Wendy was able to see what she saw and testify to what she saw, and you can look at those things to find corroboration between the physical evidence and her testimony. So, I love the statement by defense counsel. He didn't have any bruising, so none of this fighting occurred. It's good for the goose, it's good for the gander. Mr. Baptista didn't have any bruising, so this fight didn't occur, right? Ladies and gentlemen, if Mr. Baptista is in there in the fight for his life, it has two tiny little marks on him, does that seem reasonable? No. And as to what was said at different times in different places, Wendy Gambolas just saw her boyfriend covered in blood. It's a very striking, visceral image when you see that white shirt absolutely covered, drenched in blood. So think of her state of mind, and she's giving a statement to law enforcement. Her boyfriend is in an ambulance. She knows he's been stabbed. She knows there's a knife. She sees the blood that went flying. She doesn't know what his medical condition is, if he's alive or dead. So every little detail that she doesn't go into, before she has time to sit and process and think about what has just happened. So defense said, well, he didn't pick up the hat. If he was out of the car, he would have had time to pick up the hat. He just killed somebody. Hats aren't the first thing on your mind. His first thing on mind was to get out of there before the cops showed up because he knew he was in the wrong. That is consciousness of guilt, ladies and gentlemen. The other argument defense makes is, well, the knife wasn't doing anything. The medical examiner certainly testified otherwise. And if the knife wasn't doing anything, the 7 stab wounds that are attributed to this defendant, Armando Baptista, did nothing. But the 1 stab wound by Demetrius Elder suddenly cures everything and makes it stop? That doesn't make any sense. And now Demetrius Elder, who's so frail, can't even get up, can hardly walk, talk, chew food, he's going to get out and get involved in this? So let's talk about the bottle. Defense says we can't explain the bottle, broken bottle being in the car. Yes, we can, ladies and gentlemen, because Demetrius Elder's DNA is on that bottle. And that story about the bottle changed so many times from Armando Baptista to when we got with Demetrius Elder, because they didn't know about the DNA. And then once they do, they have to change their story. Because it went from the victim brought the bottle to, oh, well, he must have reached in and grabbed it. Wait, hold on, let's think about that. He's struggling, he's fighting. Armando Baptista says the victim is having 2 hands to keep him back. But the victim can reach in and grab a bottle and break it? Doesn't it seem more likely than that Demetrius Elder had that bottle in his hand because he was drinking from it that night with the bottle caps right there in the center console? So, ladies and gentlemen, defense also said if blood tells the story of where the fight occurred, then that also shows that the fight occurred outside. Because there is blood on the passenger side, back passenger door, there is blood on the passenger door, and there's blood on the front windshield. Now, the defensive wounds. It's not just the location, it's also the manner of infliction. Because the medical examiner testified that some of them were stab wounds, meaning that the depth was greater than the length, and some of them were incised, meaning the length was greater than the depth. That's the difference between stabbing and slashing. We have the incised wounds on the victim's forearm and finger, trying to prevent himself. For the testimony of Wendy Gambolas to not be found credible, you'd have to disbelieve all of the physical evidence. Wendy testified she saw blood go flying. That's before the cars were covered, ladies and gentlemen. She doesn't know what the car looks like, what blood is on the outside of that car. How does she know that blood went flying but for the fact she saw that? And that was outside of the car. So Mr. Baptista wants you to believe that he is terrified, sitting in this car, needs 2 hands to fight off Fakhruddin Mohammed men. But he can still take a hand that's preventing himself from being stabbed or slashed with a bottle with no injuries on his hands, and you have pictures of those. Get his pocket knife out, open it up, and then attack the victim. And that's self-defense. Ladies and gentlemen, it doesn't make sense if he's sitting in a car. So That brings us to the why. Well, why? Why? There's no motive. There's no reason for Armando Baptista to stab Fakhreddin Mohammed. No beef between them. They've never talked. No issues with Demetrius Elder and the victim. Oh, but wait, ladies and gentlemen. You do know why. Because Armando Baptista takes the cheap shots.
Objection, improper comment. Overruled.
He, and testified, he went from Walter Stanley. He sucker punched him. Armando Baptista took the cheap shot. He had the knife in his hand already when he was having a conversation outside of the car. That is when this altercation occurred. That is when self-defense was proper to be used by the victim, not by Armando Baptista. So yes, ladies and gentlemen, the state does agree that this is a self-defense case. But it's a self-defense case for Fakhreddin Mohammed Knight lost his life trying to defend his life against this individual who's hit him, sucker punched him for no reason. Ladies and gentlemen, you have the time, you have the evidence. Go through and look at it again. Review the statements. View the videos that you want to. You have the necessary evidence, the testimony, to find Armando Baptista guilty of manslaughter, and that during that crime, he used a deadly weapon, the knife. Thank you, ladies and gentlemen.